You want to lend someone some money and have it secured on that person's property. Lending the money is easy. Getting the right documents to secure your loan is much more difficult. What to negotiate, what forms to use, what clauses to type on, all this is important to make sure that you have a valid and enforceable document. This is Juliana too, and I originally did not think that this topic would be that much of an interest in it. However, surprisingly, I got a few phone calls within a short period of time from a person who was personally lending some money and they didn't know what to do. So here we are. As mentioned in my part 1, the promissory note, there are 2 documents that are required. We talked about the important promissory note in a previous video, the link of which is down below. And now we're going to talk about the other document, the deed of trust. Be sure that you look at the other articles and information on this topic in my video description below. But first, let me go through the disclaimer. The information contained in this video is only intended to provide a guide in the various California-only transactions to which the information is applicable. No representation is made as to the legal validity of the information or the adequacy of it in any specific transaction. The information contained should only be used after consultation with your own legal and financial counsel. So you might wonder, why is it that we're covering these topics about lending forms? Once in a while, a buyer of a real property may want to pay the seller the purchase price in installments through a time period. There may be several different reasons for this. The buyer may be unable to qualify for an institutional loan or a regular loan, or the buyer feels that he can get a better interest from the seller, or the seller prefers to get the income the interest will generate, or the seller prefers to get his proceeds in increments paid to him throughout the years instead of all at one time. This has to do with income tax purposes. Or this could be someone who has money and wants to help somebody by lending them the money, and they want it secured on real property. Now, there are basics to know about what kind of an agreement to write up for this loan. Before we define some of the basics of the deed of trust, let me clarify a very important terminology first. As escrow agents, we often get calls in which the word deed is used interchangeably with deed of trust. That is a big no-no, as the 2 documents have a totally different function. A deed is a conveyance document. It transfers ownership from one person to another. The deed is not a deed of trust, because a deed of trust is a loan document to secure the note to the property. It is part of a 2-document loan agreement, and it has to do with borrowing money, not transferring ownership. Also included in the terminology and forms is the promissory note, or the note, which is the written statement on how the loan is to be repaid. The note itself does not have to be secured on the property, but when it is, a deed of trust is used. I talk about the promissory note on another video link. Please be sure you watch that link in the description below. Now, the other document that we are going to be looking at is the reconveyance, or the recon. This is the form that releases the liabilities and responsibilities of the loan and its security once the loan is paid in full. Now, in a deed of trust, here's the terminology that you need to be concerned with. And it is important to know that though both are lending documents, the terminology in the deed of trust document is different from the terminology in the note. What we have is a trustor. This is the person who is borrowing the money. We have a beneficiary. This is the person who is lending the money. We have a trustee. And this trustee is the neutral third party who will issue the release once a loan is paid in full. He has the power of sale, which means that he is obligated to help the beneficiary conduct a foreclosure if the trustor does not pay. A word of caution again, the trustee is not the trust deed. As again, one is an entity and one is a document. The trustee is not the trust deed. They sound the same, but they are different. Again, the function of the deed of trust is only to put the loan on the property. It does not state how the loan is to be paid. That is in the promissory note. But just know that the note can exist by itself, but the deed of trust cannot. The deed of trust has to exist with the note. So here we are. The trustor borrowing, the beneficiary is lending, the trustee is a neutral third party, and the trustee has a power of sale. Remember, trustee does not equal to trust deed. Here are certain requirements that are going to be needed to be incorporated into this particular document. First of all, it has to be in writing. It also has to have an amount, the $300,000 here, as you see. And this amount has to match the amount on the note. A lot of things on the deed of trust has to match the note. If not, it's like two halves of one whole. They have to match. So the loan amount has to match. The date on the very top of this trust deed has to match the date on the note. It has to have a property address right here. It has to have a legal description so that it can be filed officially and correctly in the county records. Again, in writing, an amount to match the note, a document date to match the note, a street address, and complete legal description of the property that you're going to use as a security. The name of the borrower and the beneficiary, here's the borrower, here's the beneficiary, has to match exactly like the note. There has to be an address for the beneficiary, the trustor, which is right here, 123 West Main Street, as it says, because in case there is a default, the trustee will know where to mail all the default documents to. So there has to be an address for the trustor. There also has to have a good return address for the beneficiary right here, because the document, after it is recorded, has to be mailed somewhere. And if they don't have the right address, the beneficiary will never get the document back. This document has to be signed by the trustor, and it does have to be notarized because it has to be recorded at the county recorder's office. Here's a small tip for you. Getting a copy of the last recorded grant deed on the property will show you the name of the owners of the property, which will be the borrower, and it will show you the street address and the complete legal description in order to help you prepare for this document. So what did I just say? The name of the trustor, the beneficiary, and the trustee has to be on the document. They all have to match the note. The address for the trustor has to be showing, and also the return address for the beneficiary. The trustor has to sign this, and it has to be notarized. Now, there are certain conditions that can be put onto the deed of trust. These have to be negotiated between the parties. Some of them are incorporated into the note. Some of them appear in the deed of trust only to give constructive notice. So these are some of them. First of all, the due on sale clause, as you can see right here, the due on sale clause, it says that the loan must be paid in full if the property transfers ownership. This is a certain condition. Another condition could be the subordination clause. which means that the loan, this particular loan, can be subordinated to a new loan to be put there in the future. There could be a partial release, meaning that if you pay part of the loan off, then the beneficiary will give you a partial release of the whole loan. There could be a cross collateralization statement saying that this loan is secured on various properties, more than one. So all these conditions have to be reflected in the deed of trust. What happens afterwards? Well, as I said, the deed of trust has to be signed and it has to be notarized. And of course, after this is done, then you have to record the deed of trust at the county recorder's office. This is recorded at the recorder's office where the property is located. Very important, because we have had some people recorded in the county that they lived in, not in the county where the property is situated. Once it is recorded, then you won't be afraid that anybody is going to miss this loan, because once they search the property records, they will see the loan come up. What happens when the loan is paid off? And this is when the trustee, the neutral third party, comes into play. The two documents, the note and the deed of trust, get sent to the trustee for reconveyance, also known as a deed of reconveyance. This will release the lien, and this release of the lien is also going to be recorded. Sometimes the beneficiary himself will issue the reconveyance. And if that is so, he can sign a double form, what we call a substitution of trustee and full reconveyance. And this will have the same effect as a simple deed of reconveyance. Once he does that, he will give the original note and the original trust deed back to the trustor. Then he will mark on the note and the trust deed that it was paid in full. If the borrower or the trustor does not pay, then the role of the third-party trustee becomes very important, where the power of a sale comes into play, and with notification from the beneficiary, the trustee will then have the right to sell the property in foreclosure so that the beneficiary gets his money back. Like a piece of real estate, these two documents, the note and the trust deed, are also proof that you have an asset in somebody else's property. So it should be treated with all due consideration and care. Please do not lose these documents. You're going to need to give them to the trustee to get the loan released or to start the foreclosure proceedings. When interest rates are low, the need for a seller to carry back a part of his net proceeds to give to the buyer is small. But there are always cases when the buyer may not have enough of the down payment and needs help. Family members can step in, they will give a loan, and they will need to know this whole process so that the loan becomes a formality and their investment is protected. Because it is an asset and because there's so many variables, the requirements and conditions to consider are important. So the borrower and the lender should consult with their legal and financial counsel whenever they are negotiating this loan, because it requires certain knowledge of certain sections of the law, either the Business and Professions Code or the Civil Code. Once you have all these conditions set, then you should get a knowledgeable professional to prepare the documents, because errors may invalidate parts of the note or trust deed, and they may not be caught until years down the road at a crucial time. So if you are going through an escrow transaction, the escrow officers may help you, but it is always up to you and the client to make sure that you get your own independent legal counsel to review these two documents and make sure that it properly reflects the agreement and will stand up in a court of law. But if you wish to prepare the documents yourself, we do have these forms available. You can access them in the link below and prepare them yourself. My t-shirt for today is ziplining in Alaska, as you can see. Ziplining in Alaska. If you have not been there, take some time to go there. Alaska is a wonderful country, but you need to go there before climate change melts all the glaciers. While you are there, be sure you do some zip lining up and down the mountains. It's really fun stuff. This is Juliana too. Be sure that you have checked out my video, part 1 on promissory notes. A link of that is in the description below. I hope you have gotten some important information here. I thank you for watching, and I shall see you in the next video.